this feeling of how Constitution matters in our everyday lives. Please, sir.
Good evening, everybody. Thank you very, very much, Prasanna. Thank you, LiveLaw. It's a pleasure and privilege to be on this platform. The subjects that you have chosen and the wide range of subtopics that you have selected is very interesting, and I hope it proves to be a stimulating discussion this evening. I would therefore request first and foremost that you should increase the time of Q&A to 30 minutes at least, so that people can ask questions, and that way we will know the views of people also in a much broader sense. Now, why Constitution matters and what's the role of the bar is something which we have to really seriously introspect. What is a Constitution? Constitution is a code of conduct. Constitution is a contract amongst people. Constitution is a way of life. In any family, take for example, we all live in families. In every family, we have code of conduct. It's not necessary that it should be written, but we have a code of conduct. Now we follow that code of conduct. Likewise, a society or a nation also needs a code of conduct. And if it didn't have a code of conduct, if it didn't have rules of, rules to conduct themselves, then it would be a lawless society. So essentially, Constitution provides rule of law, and it provides means to people to understand what their status in society is, and for those in power to understand what their responsibilities and duties are. It's therefore, Constitution is a document which is equally relevant for the governed and those governing. And this is something which we have to understand, that Constitution is woven into our lives on a daily basis. We all breathe, Constitution all the time without realizing that we are actually breathing Constitution. For example, take right to life. Now, we have therefore right to a better environment or a safer environment. We would therefore expect that when, my breathing becomes difficult because of polluted air, do I have a right, and do I, enforce that right through any mechanism, including going to a court, so that we can have a better environment and the pollution levels can be reduced. Likewise, there are millions of rights which the Constitution in one form or the other provides. And those rights, therefore, govern us. Constitution also creates organs for the governance of the nation, like the executive, the legislature, and the judiciary. Each of these organs governs us in different ways. And these organs, their powers are defined under the Constitution. Their duties are defined. And, the checks and balance over each other, each of these three institutions of the state are also well defined in the Constitution. These are all done in a modern state, in a modern nation, and in a modern democracy like India, to ensure that the country grows to become a vibrant democracy, a vibrant nation where, the Constitution, the constitutional principles and constitutional ethos constantly govern at least those who are in power in legislature, executive, or judiciary. And of course, for the citizens to understand their rights and enforce those rights, all the time. If there was no Constitution, there'll be no safety for anybody. Everybody will become unsafe. For example, take right to life. I mean, anybody can take away your life without any, any procedure of law, established procedure of law. Or your liberty can be taken away without established procedure of law. Or your property can be taken away without giving you compensation and without following the constitutional mandate under Article 300, capital A. Now, therefore, Constitution assumes extremely interesting facets of our daily life without us, ordinary citizens, realizing how Constitution matters. So Constitution really actually matters because, it's like blood flowing in your veins. Constitution flows into your life in every which way that you can think of and dream of. without actually realizing it, without actually, sensing it all the time. But it is all pervasive in one form or the other, whether it is in form of rights or in duties or in form of governance. So constitution therefore is really very, very crucial to a modern democracy, and particularly a democracy like India, where constitution must matter the most, because the preamble of the constitution tells us about equality, social justice. Now these are all concepts which are so important in a society where there is tremendous divide amongst the people, and the gap between the haves and have not has increased many fold times. Constitution therefore strives, or rather aims at bringing about social justice and equality and equal distribution of resources. Now all that is something which really is extremely helpful for a nation to grow in a systematic way, in a responsible way, and in a way where everybody will become happy. Ultimately, what's the purpose of an orderly society? The purpose of an orderly society is that everybody is happy and gets that happiness which a citizen deserves. So in that sense, constitution has extremely interesting facets. So far as the role of the bar is concerned, we must realize one thing, that it is only the lawyers who understand, who read the constitution. I mean, everybody is actually expected to read, and especially those in the executive and the legislature are expected to read and follow the constitution. Unfortunately, in this country, very few people really in governance understand or even care to read the constitution. As lawyers, we are trained to read the constitution. And our role, therefore, becomes extremely important, because as lawyers, we have to constantly create awareness amongst the people, the citizens at large, as to what their rights are, and what are the responsibilities on the part of those in governance. And if those rights are violated in any manner, which they are on a daily basis, then how they can get redressal against violations of those rights. Because, in a country where illiteracy is so widespread, in a country where, people are, I would say, extremely poor. Our level of poverty is unimaginable. Nobody really knows exactly how much. In a country which is so deeply divided on caste considerations for thousands of years, in a country where, religious differences are constantly simmering and creating unfortunate problems. In a country like this, it's very important that the lawyers can make a constitution, or rather take it to the people, so that people can understand what these rights are about. And unless we do that, it would, constitution becomes a meaningless document, because people must know, and everybody must live, or swear by the constitution. Everybody must understand the constitution and respect it as they would respect their, religious scripts like Gita or Bible or Quran or Guru Granth Sahib. Likewise, constitution must be respected and loved by citizens. And for creating that respect, for creating that love, it's very important that lawyers play a very, very important role. So that's one aspect of the bar, namely educating people. The other is enforcement of the rights of the citizens, which is extremely serious, because large number of citizens are deprived of their rights, constitutional rights, fundamental rights, other legal rights, or basic human rights, from time to time. And they must therefore have redressal mechanism where they can approach the court. Lawyers therefore have a great responsibility to defend the citizens against the arbitrariness of the state, against the illegal actions of the state, which violate the rights of the citizens in any manner. So this becomes very important. The third, of course, most important role that the bar can play is to see that the three organs of the state remain within the limits of their powers. Now, this is very important, because although the Constitution provides checks and balance, amongst the executive, legislature, and the judiciary. But all these three must be checked by an outside, force, and that outside force can be, media or the bar, and they must constantly, therefore, keep a vigil as to transgressions of constitutional limits by any of these, organs of the state. And they must, as and when the transgressions take place by whichever, entity, they must really be able to discuss that, must take it to the media, and must put it to the nation that these are the transgressions, so that, some kind of a moral pressure develops and these transgressions can be controlled. So, because the whole purpose of, stopping these transgressions is to see that the constitutional principles, constitutional morality is enforced in the country. And if we are unable to enforce that strictly, which unfortunately we are not today, then, it is bound to result into a very serious failure of the state, and which we are witnessing in many forms today. That state has failed in, so many areas, and citizens are left without any remedy whatsoever. Your voice is not there.
On that note, I'm reminded of the lecture that you had given to the Supreme Court Bar Association in 2018, when you were still then former president. So you had mentioned, you had in fact cited the rule in a Bar Council of India rules that in fact lays down that members of the bar shall not be servile with the judiciary. And you had cited that, and in fact, one might say you lamented that we have a lot of senior members of the bar that are not speaking up against the transgressions of the judiciary itself, not keeping the bench the check. So I wonder if that has changed over the last couple of years, and what are your views on where we are right now on that count?
No, I have no doubt that bar must speak and speak more often, and must speak, of course, in a responsible and respectful way, but in an extremely persuasive and forceful way if necessary. In fact, besides those rules under the Advocates Act, which the Bar Council has very beautifully framed, the Supreme Court Bar Association's aims and objects also speak about this. But a recent, judgment by from the Supreme Court, written by Honorable Mr. Justice Arun Mishra himself in a Tamil Nadu case, where he spoke about the responsibility and the role of the bar, he in fact puts it, so beautifully, in that he says that the bar and the bench are ultimately cornerstones for a democracy. And the bar has a great role to play in ensuring that democracy in this country not only survives, but thrives. And he therefore calls upon members of the bar in that judgment that they must really stand up and speak. So, that's a very, very, interesting judgment. And I would definitely recommend members of the bar to read that judgment, because some of the passages of that judgment are very, very powerful.
I'm sure many of those passages of that judgment are going to be pressed into service soon, because it is a season for contempt petitions, particularly against members of the bar, as we know. But because it is a sub judice matter, I don't want to get into the details of that matter, but we go on to the next topic, next segment that I have on civil liberties. So, in fact, one of the recent cases that you appeared in, and one of the more celebrated judgments of late from Supreme Court, was the Anuradha Bhasin case, where although there was no relief granted in terms of all the restrictions, telecom restrictions in the state of Jammu and Kashmir, but that the ratio of that judgment apart, there is a feeling, certainly several scholars have written about it, where in matters of civil liberties, the Supreme Court, our Supreme Court, appears to have deferred largely to the executive and what the government has to say. And juxtapose this with the general perception that the Supreme Court is, in fact, several scholars have also written about how the Supreme Court of India is the most powerful court in the world. So how do you rationalize both of these?
Well, in theory, the Supreme Court of India is the most powerful court in the world. I would agree. But in reality, I think the Supreme Court is definitely sitting back, and it needs to be far more proactive than what it has been in many areas. In fact, not just the Supreme Court, but the judiciary in the country as such, because it's not just ADM Jabalpur which has really been, I would say, a black spot in the history of India's post-independence judiciary. I think judiciary's role, especially in 1984 riots in Delhi and 2002 riots in Gujarat, has been extremely disappointing. And as we have all seen, that I mean, none of the perpetrators of those riots, the political leaders or the top bureaucrats or the top police officers who were responsible in failing, I would say, I won't say that they actively did it, but who were responsible in failing to protect the lives of thousands of innocent men, women, and children. I mean, they should have really been taken to task. But I think, judiciary has developed this beautiful weapon called public interest litigation, but it is rarely used when it comes to lives of people, especially of those who belong to the minority communities. And this is a very, very, I would say, disappointing and disheartening, approach on the part of the judiciary. They had a duty, and they had sufficient powers to have intervened at that point of time to at least order independent, fiercely independent investigations and to bring to books those who were responsible for actions or inactions, as the case may be. Besides that, in many cases, for example, look at just now the Uttar Pradesh situation. In last 2 years, almost 200 people have been encountered in Uttar Pradesh. Now, I mean, it's very shocking that judiciary has, I mean, Supreme Court has not taken suo motu cognizance. See, we are now creating this culture, and this started in Maharashtra when Congress government was there, when one particular police officer was known to be encounter specialist, and he was proud to be one, and he was hailed as a hero and given many medals. And later it turned out that he was actually taking money from opponents to kill the opponents. So I mean, it was sad. I would say that the judiciary had a duty to stop these kind of encounters, because the encounters actually, judges must realize, reflect failure of the judiciary. Because why is it that the police indulges in encounter, and why is it that society at large approves it? It is because the judiciary is, delaying, criminal cases to such an extent, and ultimately, even when the cases are heard, the percentage of conviction in this country is just about 15%. In a country like Japan, the conviction rate is 99.99%. Now, there are two reasons for it. One, that in Japan, rarely would a wrong person be brought to justice. In India, it happens all the time. So that's first reason. Secondly, the investigation is very scientific in Japan, which is not there today in India. And thirdly, the judiciary acts very quickly. Now, we need judiciary must understand that if we want people to believe in justice delivery system, because they are fast losing their faith, then judiciary will have to act. And it's not willing to act. See, for example, since COVID came, for last 3 months, 4 months, virtually entire judiciary in the country is paralyzed except for so-called urgent matters. Now, that doesn't augur well for society at large, because, there is responsibility to ensure that at least in cases of civil liberties, where, people are in jail on bail, because, what happens is that large number of people in this country face jail for n number of years, and ultimately they are acquitted either by the first court or second or third court. And, it has virtually ruined their lives for no reason. Now, in a country like United States, for example, or even in Europe, almost everybody gets bail, except in, rarest of rare cases where somebody would be denied bail on charges of terror or something. So that's the kind of a thing. The judiciary here does not grant bail, and does not therefore decide the cases well in time. So liberties of citizens are seriously, I would say, not only challenged, but virtually taken away for all those years that they end up spending in jail. And, there are a large number of other cases. For example, take, recent riot cases in Delhi. the judiciary needs to look at it very differently than what it has done. Far from the provocateurs being brought to justice, innocent people are being brought to justice, and nobody is, able to say anything about it. So, it doesn't speak well for us as a nation, because judiciary is expected and must be fiercely independent and should be, in one sense, judiciary is, is really in the status of parent of citizen. And as parents, they should really be extremely balanced. They should not have, any side. A father or a mother would never, if they have two children, would never, pick up one against the other. They would always give the same love and affection to both of them. Judiciary, therefore, needs to look at citizens with that, eye of love and affection towards every citizen. And once they do that, then the whole justice delivery system will change. It's slightly, I would say, skewed against certain sections of the society. It's not just the minorities, but even the underprivileged and the Dalits face a lot of problem, and and are not getting justice in most parts of the country for whatever reasons. So it is high time that judges, and I would therefore appeal to the Supreme Court, that because the judges of the Supreme Court have far broader understanding, far broader viewpoint, and a far liberal approach, and they would be I would say, well advised to really take note of the prevailing situation in the country, and send very powerful messages through their judgments, and by so that people really, subordinate judiciary really understands as to what is right and what is wrong. Today, I would say that there is no, guiding principle which guides, subordinate judiciary to deliver justice fiercely, independently, and, in terms of the constitutional ethos and four corners of the constitutional limitations. So that is something which people have to be made to understand, that right to life and civil liberties, right to liberty, is something which is so sacrosanct. It is so basic. And Justice Khanna very beautifully puts it in his judgment in DDM Jabalpur, in his powerful dissent, which every lawyer must write. He says that, these fundamental rights are not fundamental because they have been put in, chapter 3 of the Constitution as fundamental. They are fundamental because they are basic human values. And if these basic human values are not protected, by who will protect ultimately? The state is expected to protect. But where the state fails, who then comes into play? The judiciary comes into play. And judiciary has to therefore ensure that those rights are protected to the hilt, and without any kind of discrimination of religion, caste, race, or gender. They must enforce them, absolutely and literally. Then alone we can say that we are successful as a democracy, and that the Constitution which has been given to us is really working well for the welfare of the people.
Staying on the topic of judiciary, so you've actually looked at some of the functional aspects. What is it that the judges can do better, and what is it that we may need to do? But for a moment, if we have to focus on the structural aspects, what are the reforms that you think are necessary, that are urgent in our judiciary? Whether is it the office of the CJI? Is it the appointments process? Do we have more safeguards in the removals process? So what are the structural reforms that you think are urgent and necessary?
Structural reforms are very virtually impossible to bring in this country. I don't think, judiciary essentially by temperament is status quoist, and they don't want any changes to be made. So that's first thing you must understand about judges. But, we have excellent judges. Some of the judges are outstanding. They are world-class judges. And the difficulty is that collectively they are not able to do what is expected of them. Individually, they may write good judgments. They will do absolute justice. They are very, very fine, and they are very learned. But what is to be expected, what is to be done is that they must put their, their energy, their intellect, their resources together They must pull them to really to pull the judiciary out of the slumber that it is in virtually in every part of the country. Somebody must guide them. It is wrong for Supreme Court to think that High Court is independent and we can't guide them. It's very important for Supreme Court to have constant. It's not enough to have one conference in a year of Chief Justices and you have some nice, bhashans and just forget about it. No, I think it would be better if the judges were to interact with the High Courts on a weekly basis to talk to them as to what should be a judicial approach, what should be, the administrative approach, which are the cases which require, to be dealt with early, what is it that to be done about how to work within the limited resources that the government gives, how to, do better management techniques so that, the docket moves quickly. All kinds of things can be, talked about amongst the judges. Bar should be involved in that process in an extremely, positive way. And I have no doubt Bar will have a lot of suggestions to make. But this kind of an approach of an all India, I would say, commonality of mind or meeting of mind has not taken place at all. And that's one of the reasons why the subordinate judiciary, which is really the backbone of the judiciary, is, I would say, unguided in that sense. Subordinate judiciary has outstanding judges and they do tremendous hard work with extremely poor conditions of working. And, but they need guidance, they need support. And both must come from the Supreme Court and the High Court constantly. Then they can work, better so that, you have almost something like 40 million cases pending in subordinate courts today. That doesn't augur well. It's not just civil liberty which is important today. Citizens' private rights are also extremely important. Somebody's farm is gone, somebody's house is gone, somebody's job is gone, somebody's pension is gone. And likewise, the fights, the disputes that citizens have with the government, who's the biggest litigant, because today government is omnipresent. So those disputes between citizens and government, even if supposing there is a dispute as to payment of GST, from a trader, the government has demanded, let us say, extraordinarily exorbitant sum. The trader, the court expects him to deposit that today. The trader deposits it. Now, you are not going to decide his case for 5-10 years. He will die. He will economically die. Therefore, there are many ways where, judiciary needs to have some kind of a approach which will really go a long way to improving the functioning, the performance, and the outcome of their verdicts. Then alone, perhaps we can say that the administration of justice has been well served. And we can do it, as I said, with so many good judges. It's not difficult. It's just the initiative that has to be taken. I don't know who will take the initiative. That's a big problem. I have many a times felt in the past and discussed with the Honorable Chief Justices as to why they don't constitute some kind of a committee to give them a report about these kind of, internal reforms without, not a structural reforms, but internal reforms on the working. And nothing has, I have never seen a positive response in last 20 years, 25 years or 30 years that I have been in Supreme Court. So it's difficult for us to, we have to wait and watch what happens.
I see. Yeah. Moving on a little bit from judiciary, of course, we've talked a little bit about judiciary, but the Constitution is much more than just the judiciary and its functioning. I also want to dwell on secularism as a value. Where does the Republic stand in terms of secularism as a value, particularly in the backdrop of the CAA, the protests that have followed, and the cases that have followed, the riots that have followed? Where do we stand? What is your views on India's secularism as it stands in 2020s?
See, people have seriously misunderstood secularism. In fact, now it's become a word which is being condemned by a lot of people. But secularism is nothing but respect for each other. Ultimately, basic principle of human life is respect for others. And that basic principle is, to be found in a constitution. Under our constitution, secularism, the word was inserted in the preamble much later. But the original constitution is founded on the principle of secularism. And, the protection of the minorities in Articles 29, 26, 27, 28, 29, 30 is really something which is founded on that principle. Because the constitutional framers were extremely conscious that we must protect the culture, heritage, and the religious beliefs of this small group of people who are not the majority, who are not going to be the majority in the country, and they will be minority. The minority in that sense was on the basis of the size of the population and not on the basis of merely religion. It is seriously misunderstood. So the constitutional framers wanted these, small group of people who did not profess, the religion of the majority to be protected at any cost. And that is why they gave us various measures. Now, so far as, secularism is concerned, everything cannot come, from the written document. It has to come from the mindset. We have to learn to, respect each other. We have to learn to love each other as citizens. And unless and until we do that, it is very difficult for us to have genuine secularism in a nation. Because, there is so much of distrust amongst us about certain, communities, which is extremely unfortunate. Because, and especially, for educated people, because, one of the things that educated people must understand is that Constitution creates equality. Everybody is expected to be equal. And that equality is not just on paper. That equality is in everything. And you can't therefore, treat a group of people separately and except so far as the cultural and religious, beliefs are concerned, which are protected. In fact, Dr. Ambedkar was so worried about this aspect of the minority community, the Muslims. He was extremely worried. And he had said very prophetically that, and this is something very important on the last day of the Constituent Assembly debates, he said that I am criticized for these provisions in the Constitution to protect the minorities. But let me tell the diehards that those Muslims who had a choice to go to Pakistan have gone. But those Muslims who have remained in India have decided to remain in India despite that choice to go to Pakistan. And he says that therefore they have placed their faith in the hands of the majority. And the majority therefore is expected to really take positive steps to ensure that this minority which has remained back is, becomes part and parcel of the society. And he warns that minority is an explosive force. And if they are not well treated, then it will result into serious, issues for the nation. Now, that is the warning which Dr. Ambedkar gave on 25th of November, 1949. Sardar Patel, one of the greatest leaders of this country and who gave us beautiful, nation of these republics. Sardar Patel, who is being, I would say, recognized by the later politicians to say that he is the ultimate leader and the other leaders have eclipsed him, are eclipsed by him. Sardar Patel had warned more than once during Constituent Assembly debates and said, you, the majority, must make minority feel comfortable. You must make them feel at home. You must look after them. And if you don't look after them, the consequences are serious. Now, secularism, therefore, is very, very interesting. Ultimately, you cannot dictate the personal beliefs of anybody. You cannot dictate the personal, clothes of anybody or personal habits of anybody. Everybody has a right in a society so long as the decency and morality are not violated. Now, this is where we are seriously today at a crossroad. We are looking at a group of people and trying to condemn them for their beliefs, for the way they live, the way they wear clothes, etc., which doesn't really augur well for us as a democracy, because we have 5,000 years of history. And our religion, the religion of the majority, at least Hinduism, I'm a Hindu myself, the Hinduism has survived 5,000 years, the onslaughts by everybody. I mean, the Jainism came, went away, Buddhism came, went away, Christianity came, Islam came, and Hinduism has flourished. And the reason why it has flourished over centuries, thousands of years, is because it was willing to encompass every other belief and and still move forward. So I feel that today we are becoming more and more shallow in our approach towards religion. We are not really understanding the true tenets of Hinduism and trying to belittle other religions. We don't have to see the weaker points of the other religions. We have to see the stronger points of every religion and follow it. And I think judiciary has a great role to ensure that the secularism, that is the existence of the minorities, is in every form is protected by it against the onslaught of the majority. And this is something which needs a very serious proactive approach on the part of the judges. And I hope and trust that judges will do so as widely and as strongly as they can.
We've unwittingly come back to the judiciary at the centerpiece of all this. I want to harbour on that a little bit more, on the role of the court as a counter-majoritarian institution. And where do you think that our Supreme Court, as it currently stands, where do you think it fits? And related to that are there other structural issues? For example, we have only about, I think, 3 minority judges now in our Supreme Court with nearly 30. Do you think we may need to alter our appointments process? What is in fact, there is another audience question here as well on the collegium system. What is your view on what is your views on the collegium system as opposed to NJAC? And if there is an NJAC, what in your mind is an ideal NJAC?
See, let me answer your last question first. I am against collegium system. And the reason is simple. It was conceived with great ideas. And one of the most important ideas was that to bring the best from amongst those available. That's the word that Justice Verma uses in his powerful majority opinion in the second judge's case. Judges who have, tremendous character, they are completely free from political interference, and who can stand up and protect the Constitution to the hilt. Now, unfortunately, over the years, we must say that there have been serious disappointments. We all know that. We need not name anybody, but there have been serious disappointments in elevations of judges, and the whole process is very seriously skewed today. Where we are not able to get the best from those amongst available. We are only following seniority rule, and which is really very, very, I would, detrimental to the development of the judiciary, because we need judges who can, really develop jurisprudence, who can really develop law, which becomes, of universal application, and a law which commands universal respect. So that's something very important for judges to understand, that if they lay down law which doesn't meet the approval of people and does not command respect, then judges have failed. So I feel that collegium system definitely has failed to my mind. There are very serious question marks about many of judges, their integrity in the past, although majority of them are extremely clean, but still many judges with questionable integrity have crept in, and there have been serious question marks all around. But that happens in the system. But I would say, on the aspect of selecting the best intellectuals with great qualities, that is not really happening. And this seniority system has not helped us at all. I have seen when I started practice in 1978 in Gujarat High Court, we had, I think, 12 judges, and I would say all 12 were outstanding. Outstanding. And they were so fiercely independent, and their own lifestyle was, completely, so pure. And I mean, it was amazing to see what level of those judges were. And they were getting salary in those days of 1,800 rupees or 2,000 rupees or something. But yet their own character was impeccable. And but that unfortunately, and the level has certainly reduced. So I am not happy about the collegium system for one simple reason, that we are unable to criticize the appointments. If the NJSC were to make the appointments, at least we will have right to go there and tell them that the candidate that you are selecting is wrong for the following reasons. Today, the collegium doesn't want to hear anybody. On more than one occasion, I have personally intervened with the collegium to tell them that a particular judge should not be elevated in High Court or Supreme Court. And yet they have been elevated. And I have never even been communicated, response to my letter, which was based on facts, not on imagination. So, so in collegium system, it is completely opaque. And we don't know what happens behind their closed doors, and what are the considerations which weigh with the honorable collegium members to elevate judges, whether in High Court or in Supreme Court. So, but if it was NJSC, it would be transparent, and at least we would have a right to question, besides giving material, and to criticize the appointments. Now, that's something, yes, of course, very difficult to choose between the two systems, because the executive today has become such that it is not expected to select the best. So, but one would hope that NJSC would be constituted of fiercely independent people, and therefore those fiercely independent people will put all their minds together and do something. So, but the problem is that this country, I think we have lost a lot of ground in last 3 or 4 decades. And it is therefore very difficult for us to find men and women of sterling qualities who can take this country out of the problems that it has, whether be it in appointment of judges or in every other thing field in public life. So public life has certainly suffered immensely. And, so far as the protection of, secularism is concerned, I would say that judiciary is fairly balanced. I would not say that judiciary does not. In fact, time and again, I have seen judges coming to the rescue of people. But I would still say that judges need much more, I would say, much more proactive approach when it comes to treatment of minority by the executive and by the majoritarian community. To that extent, they should have more healing touch than what they have had so far. So that is definitely, that would go a long way in healing the wounds that minorities feel in the country.
What do you think about reservations in the judiciary, in judicial appointments?
Well, I am in favor of reservation. So, period. I mean, we have had the caste system over 5,000 years, and you can't wish it away in 75 years. Okay. Even today, in every village that you go, you find caste system is so strongly entrenched that the underprivileged and the Dalits still are not able to walk shoulder to shoulder with people of the high caste society. So, and therefore, the disadvantage with which the Dalits and others are, born and brought up are very difficult for us to really imagine. We can't really go into their mental framework to understand what kind of challenges that they face, what kind of treatment that they, are confronted with, and what kind of, mindset that they constantly have on account of these considerations. So I feel that reservation is extremely good. Reservation must be there, and reservation should be properly implemented. And I feel that it would be, although I am very clear that on religious or reservation grounds, one should not make appointments to higher judiciary. It should be only on basis of excellence. But I have no doubt that there are a large number of candidates available from either the religious minorities or from the vulnerable sections of the society or the Dalit communities, who are outstanding and who must be considered for appointment to the higher judiciary, and they should be considered. So to that extent, I do feel that they are being ignored, over a couple of decades, and that is not a good sign. So, I mean, you don't have to compromise the quality, you don't have to compromise competence, but you can still give effective representations to these, people, and that should be done. In the equally, women must have representation, because India is almost about 48% plus population of women, and we have just about 3 honorable judges in the Supreme Court. So I think even women should be given representation, because they are outstanding lawyers. There are so many of them who deserve to be considered. So I think the judicial system must be representative, and if it becomes representative on excellence basis, not on compromising quality, on excellence basis, if you make it representative, then the justice delivery automatically changes, because the justice or the injustices suffered by the vulnerable sections of the society, be it women, be it Dalits, be it the minority sections, these judges then can appreciate the problems and can fine tune the justice which is being meted out to them. So to that extent, I would say it will have serious positive impact on administration of justice.
All right. So we can now go to the Q&A section. So I'm curating some of the questions that have come in from our viewers here. That kind of melds with one of the questions that I left out as well. So I'll take this first. This is particularly, as the president of the SCBA, that the courts have all effectively shut down for most causes, except for most urgent causes, as you indicated earlier. So Musaddiq Ahmed is asking us how far suspension of these rights, the right to access justice, would be permissible to stretch given the idea of our constitution. How far access to justice may be labored with urgency in the matter?
See, I personally feel that it is not right for judiciary to have gone into a lockdown. Because to me, right to justice is right to life. And therefore, that right cannot be suspended even for a day. Nobody is suggesting that judges' lives is cheap and therefore, they should die, or that the court staff should, take unnecessary risk and they should all be, open to COVID-19. No, that's not the suggestion. We love our judges. We love our court staff. And we wish them long life and good health. But keeping that in mind, I think when every segment of society has opened up, the government itself has lifted the lockdown, there is no reason for judiciary to continue to have this lockdown and to have this farcical video hearings. I think to that extent, judges have, and particularly the Supreme Court, has done great disservice to the nation. And because Supreme Court has done it, every court in the country, every high court and every subordinate court is also refusing to really open up. And I feel that the physical hearings must restart forthwith. In fact, yesterday only we had a joint meeting of the Executive Committee of the Supreme Court Bar Association and the Supreme Court on Record Association. And all members met. President Jadhav was there, I was there, our Vice President Kailash Vasudev and Vice President Mishra were there. The two secretaries were there, Mr. Aristotle and Rohit Pandey, and every other member was there. And we had very positive and fruitful discussion for about 1.5 hours on Zoom. And we unanimously agreed that the physical hearings must start as soon as possible. And they must start, of course, with strict conditions, so that, we can protect not only the lives of the members of the bar, but also the court staff and all stakeholders. But unless we do that, we are doing great harm to administration of justice. No country in the world has shut down. What is really sad is that two of the most important checks in our constitution, the parliament and the judiciary, both have virtually shut down, leaving the executive a complete free hand. Now, this is where, there is serious issues, because the executive actions during this COVID-19, right or wrong, I'm not going into that, but must be subject to test by the parliament and by, one of the reasons why Ambedkar justified parliamentary democracy over presidential form of democracy was that there will be daily testing of the executive, of the government on the floor of the parliament. Now, you have shut down parliament for 4 months. You have virtually shut down every court for 4 months. And the high courts and the Supreme Court are the ultimate, protectors of the fundamental rights of citizens. So, it's not good. It doesn't speak well for us as a nation that this has happened. And I would appeal to the Honorable Chief Justice of India and his colleagues in the Supreme Court with folded hands that they should really immediately start physical hearings. They should sit down with the bar. They have refused to talk to us for 4 months. They should sit down with the bar to take, to decide as to what kind of precaution should be taken and then restart. Today, they have said that they have appointed a committee of 7 judges and in 4 weeks, they will decide. Now, why did they wait for 4 months to constitute a committee of 7 judges? It's sad. If at all, they should have done it on 23rd of March so that we would have had, the entire system in place. So, I would say this is nothing but just an act to defer the ultimate. Apparently, there may be some fear amongst the judges, but then everybody has to take the risk. I have said, publicly that millions of Safai Karamcharis have been working every day across every street in India for 4 months. And they are the most vulnerable to COVID-19. The policemen, the doctors, the nurses, you name them, people have been working. So why should the judiciary, decide upon itself? We are service providers. We cannot do this. It's sad that judges have done this, but in any other country, this would have been unacceptable. So I feel in Indian context, judges had a greater responsibility, and I would have expected much greater maturity on the part of the judges to have, re-looked at the entire exercise. I think it's sad. I only can say that.
Interesting, you mentioned the court as a service providing entity. There is a general feeling, certainly among litigants, where the court is designed such that it is very court oriented and not very litigant oriented in several of its processes, in several of its procedures and all of that. So is that true in your experience, or has there been a change over the years in that? Is it still viewed as an authority which is oriented towards itself rather than litigant oriented?
No, there is no doubt about the fact that our judicial system follows this British, form without really following the changes that the British themselves have made. And one of the single biggest problems of our judiciary is that it is too procedurally driven. And because of that insistence on procedure, yes, injustice is being done. So that is something where judges need to be much more relaxed. They need to be much more liberal, much more broad-minded to give relief. Because, you must understand, and I have no doubt judges understand it well enough, that there is tremendous injustice in our society. Either it is at the hands of the government to citizens, or it is at the hands of the rich and the powerful to the others. So there is tremendous injustice, and we are a highly litigious society because, those who can drag the other person to court are, strong enough to sustain the court, system for a long, long time. but the person who is dragged by them is unable to, sustain it. And that creates a very serious problem, because financially you can't fight it. The legal system is in, I would say, complete chaos, where it doesn't engage the best of the lawyers to defend these people. And generally all these legal aid matters you find in court, virtually every one of them is filed after time has expired, and virtually everyone gets dismissed because the representation is not poor. I sit in court many a times, I see counsels only saying it's a legal aid brief, and it's not the way to do it. The time has come that government must and the judges must revamp the legal aid system, so that the best of the people are briefed for a common man who is unable to defend himself because he doesn't have the resources. He comes to legal aid because he is unable to, get private lawyers, good lawyers. So you can't then thrust upon any lawyer. I'm not making any comment on, lawyers. All that I'm saying is that we need excellence even in legal aid services. And to that extent, I think judges owe a great duty, because, the legal aid is entirely virtually controlled by the judges in the country. And they need to sit with they need to sit and seriously introspect about it.
Moving on, there are several questions about appointments and NJAC. I'm going to just field a few. So.
I have already,
and one of them, yes,
answered
most of them. Therefore, I'm not going to ask any of them. So one thing that is interesting is what is your opinion on prominent jurist or academic being appointed as a Supreme Court judge, even somebody with virtually no practice?
I think must be appointed, because one of the things that Supreme Court is lacking today, and that you see in the judgments which are being delivered these days, which are hardly judgments, is absence of intellectualism. I mean, there are some outstanding judges who are great intellectuals, but by and large, the high courts and the Supreme Court over last 2 decades, almost, or little over 2 decades, are not giving judgments. You read the judgments, of the Supreme Court in the 50s, 60s, 70s, even 80s, early 90s, right up to Chandrachud, Bhagwati, and Krishna Iyer, Tulsapurkar, or Chinnappa Reddy. All these judges, they really gave fantastic judgments, which were really laying down law in an extremely beautiful sense. Take, for example, anticipatory bail judgment, CBA's case. The kind of approach that Chief Justice Chandrachud has in that, and how beautifully he expounds it, is something which people must understand. And that's something which is missing today in last few years. In United States, for example, it's a misnomer in India only, that only lawyers are supposed to know the law, and they are always, they are always sought after for opinions, even by civil society and by politicians and bureaucrats. You go to America or Europe, you find that the best of the opinions are given by law professors. And these are the professors who are highly respected. You see anywhere, whether, you see CNN, whether you see BBC, or whether you see anywhere else, or you read, top magazines, Economist or Time magazines or any other magazine, the opinions of these jurists, the professors, are so highly respected. We have to create, therefore, that kind of a situation where we, respect these kind of people. Take, for example, Professor Upendra Bakshi. Now, if a man like him had come to the Supreme Court, in his heydays, he would have contributed immensely to the development of law. So likewise, there are Professor Madhav Menon, outstanding. So our present Nalsar Vice Chairman, I forget his name, also outstanding. These are the kind. There are many such people across the spectrum who are so good, that we can really, the institution will benefit with their thoughts, with their level of intellectualism, and law can never remain static. Law is a constantly expanding process, and that law must be expanded to subserve the humankind. Now, you can't subserve it with old ideas, antiquated ideas, and borrowed ideas. So you have to do it with fresh ideas. And for that, I would say that jurists must be must be involved, must be considered, and must be appointed. And I am not at all worried whether they have even single days experience as a lawyer or not.
All right. There are a few questions that on topics that we've not covered so far or discussed, but they relate to contemporary political developments, and therefore I thought those are interesting ones that we can field here. One of them is whether the Constitution places too much faith on the institutions of the governor and speaker, who are by definition party appointees.
No, there is no doubt about the fact that over the years, and they started with the Congress government, so one can't blame the present BJP government alone. But the kind of people that we have appointed in the office of the governor is, I would say, sometimes pathetic. We have seen governors who have misconducted themselves so badly that one is even ashamed to talk about it. It's not an office which is to be filled up by retired politicians or even retired chief justices. It is an office which must be, filled with fiercely independent people who really can be, kind of guide to a whole state. They must be role models, and they must be in a position to take extremely independent, because ultimately a governor is a representative of the president in a state. And as a representative of the president, the governor must ensure that the state functions within the limitations of the Constitution. The state government and the state conducts itself in a proper way. So to that extent, I would say governor has a great role to play, although it's a passive role. It's not an active role. He's merely a constitutional head, so of a state. But he can certainly, he can certainly guide in a brilliant way, and that is what it should be. That the governor's position in good old days, the governors were absolutely amazing. We had, when I was young in Gujarat, we had a governor, Mr. Mehdi Nawab Jung. He was a role model. We had Mr. Nehru, B.K. Nehru, who was governor even when I started practicing. And what an amazing people they were. I mean, their own conduct was absolutely unbelievable. The way they, their level of intellectualism was very high. The way they conducted, the way they guided, the way they spoke. Even when they spoke with a message to people as also to the politicians. And it was a very subtle message which they would give, that we are watching you. So please make sure that you don't make mistakes. Now, that is something which is seriously, missing in our governors and speakers. And we, as a result of that, there is constant violation of the Constitution on a daily basis, as we see all the time. And it is something which is not good for us as a nation.
The next one, interestingly, links criminalization of politics to custodial violence and police atrocities that we've seen in recent times. So given that we moved in the past 30 years from lamenting the criminalization of politics to almost celebrating it, is there a case now to isolate the police from executive influence under some constitutional mechanism? So this is another structural suggestion that's put forth by someone.
It's a good question, but you must remember that every constitutional authority that we have created today has not remained away from the political influence. So whether it is the judiciary, whether it is the CAG, you name the constitutional functionary, and we are unable to find, fiercely independent institutions. All institutions have suffered over the years under the onslaught of the politicians. And which is sad because, the whole purpose of creating these constitutional bodies was to keep check on the executive, namely the political executive, and which has not really worked well. Mrs. Gandhi started that kind of an onslaught on the institutions, and that has continued even under the present Prime Minister, and which is not healthy because, Prime Minister Modi, in fact, can provide a system which can be so good for generations to come, and where he can be remembered. But it's not happened, and it's not happening, and which makes one wonder. I mean, as to why would a powerful prime minister like him or Mrs. Gandhi would not leave behind a legacy of strong constitutional, checks and balances, so that the democracy is nourished and nurtured in a proper way. So it's something I am not. Police reforms in this country are very difficult for two reasons. One, the recruitment of the constabulary over the years, as we are seeing, is seriously mired in controversies of corruption. We know how these constables are being recruited across the states in the country. Secondly, the nexus between the politicians, the criminals, and the police is a matter to be seriously worried about. And I don't think we can wish it away overnight. It requires a very serious introspection, and it's only a person like Mrs. Gandhi or Mr. Modi who could have really tried to dynamite that nexus. But sadly, both don't seem to have really done. And in fact, we find that even in the present parliament, there are a large number of honorable members of parliament who are having criminal cases behind them. So it's not, and in the assemblies, it's very common across the country, irrespective of political party. It has nothing to do with a party. Every political party is encouraging the criminals. So it's something which doesn't augur well for us as a democracy. And I think we are leaving behind for future generations a nation full of problems and problems alone. I don't know whether they have anything to really hope for in the future.
That note, we're still flooded with questions, so we are technically out of time, but I hope we can field a couple more questions if you don't mind.
Yeah, please.
One of them is on the Bombay High Court having refused to recognize lawyers as essential service, and how the Bombay High Court has recently disallowed their travel by suburban local train services for emergency workers. This, I must say, I've not really read about it. I've not really followed this, but if that is the case, I'm sure there are some high courts that have held lawyers not to be essential services, at least early on during the lockdown period. So was that something that you agreed with? Was that something that the bar generally agreed with?
No, with great respect to the Bombay High Court, I don't think it has taken the view correctly. You may not call a lawyer providing an essential service, but a lawyer is a part and parcel of the administration of justice, which is an essential service, which is, as I said, which is really, which is a fundamental service. The basic structure of the constitution is judiciary and justice delivery. Now, if you interpret it in that sense, you can't isolate the lawyer and say that lawyers will not be allowed to go, and yet the system will be treated as basic or fundamental to the functioning of the constitutional, system, because without lawyers, they can't. So I think it is a very narrow view which Bombay High Court has taken, and I hope the Supreme Court will reconsider that view, because lawyers should be allowed to go. And I remember, I remember Chief Justice P.D. Desai, who was then judge of the Gujarat High Court, and riots had taken place way back, and as a result, the city of Ahmedabad was in lockdown. And I was a young, assistant government pleader, and somebody mentioned to him in the morning at 11 o'clock that lawyers are unable to come from the old part of the city because of the curfew. And he called me and he said that you please tell the commissioner of police that if any lawyer is prevented from coming to the court, I will initiate contempt proceedings against him. Now, that's the level of love that, judges had. And P.D. Desai is my role model. He became Chief Justice of, Himachal, Bombay, and Calcutta and Bombay High Courts, and refused to come to the Supreme Court when he was invited by Chief Justice Venkatachalaya. But amazing. I mean, his heart used to throb for, justice. And this is one example. Another example, I remember there was a playground, common municipal playground, where the state police had, during the riots, pitched a tent and had occupied it. And the children just, telephoned the High Court to say that our playground is taken away. And I remember he called me and he said, I want these tents to be removed within 1 hour. So we had to do it. And, and the whole administration knew who P.D. Desai was. And they would never, ever make the mistake of not following his directions. Because the power of contempt that he wielded in a right way was so beautiful. And he genuinely believed that judiciary must be respected. And respect must be commanded by the judiciary by exercising this power. Today, that's singularly missing. The judges are just refusing to take any contempt initiative against the executive, while they are quite willing to take against the citizens. So it doesn't speak well, because the authority of judiciary is diluted on account of that. I would say that lawyers provide an essential service in an overall structure of the system.
There are a few more on the structural questions of our judiciary. There's one that is asking what your views are on the establishment of a national court of appeal and a separate constitutional court. So it is basically to break up the Supreme Court.
No, I don't think I'm against any national court of appeal. Frankly, time has come for us to really realize. For example, the greatest damage that we have done to this country is tribunalization of administration of justice. We have taken away from the High Court's powers virtually under every act and conferred on these tribunals, which are, law unto themselves. These tribunals are so unsatisfactory. They are thoroughly inefficient. They are manned by incompetent people, and the allegations of corruptions are very serious there. And therefore, I am very much against these kind of creating additional this thing. What we need, we can easily answer the problems that we are facing by appointing the best people in the subordinate judiciary and in the High Court and the Supreme Court. If you have the best people, then giving the judgments, the High Court knows that the judgment given by these subordinate judges must be good judgments. They are well written. We know that their integrity is unimpeachable. We would therefore not interfere. Likewise, when High Court gives the judgment, Supreme Court must know that these judges are giving judgments which are not only sound in law, are well considered on facts, but they are by judges who are impeccable in character. Why should we therefore interfere with their view, even if they have taken a particular? So the system has to be inbuilt to reject this kind of multi-layer appeals that we have. And every case appeal need not be filed, and even if filed in the Supreme Court need not be entertained. So what is really happening today is that the Supreme Court is too liberal in considering cases. Therefore, the bad cases get in, and sometimes the right cases don't get in. So I think National Appellate Court is not the answer. Answer is to strengthen the existing legal system by manning people of absolute, competence and excellence and unimpeachable integrity. And that's the process which is very difficult for us to achieve.
Another one to put you on the spot as the bar president. What are your views on the establishment of different benches, perhaps in South India and East India?
No, I don't think it would be good for the Supreme Court to be split like that. Even within the same building, the judges are not following the judgments of their brother judges. So if we have these benches, in other cities, they would perhaps start ignoring the other court altogether. I don't think, yes, what we need is, to a litigant, the cost is very heavy. As I said, that therefore we need to really improvise the legal aid system in a much better way, much finer way, so that litigants who cannot approach the Supreme Court, because of cost considerations, are really taken care of. Otherwise, I don't see why we should have any other bench of the Supreme Court anywhere. I am against even the benches of the high courts in, states. In fact, they should not create so many benches. They should have only one seat, and that's the end of the matter.
All right. Thank you very much, sir. We'll close with one personal question that I keep dismissing, but that question seems to keep popping up. Why did you personally choose to remain in law practice as against joining the judiciary? I think you might not have expected this question here, but please do go ahead. Feel free to answer.
I must tell you that it is not difficult to answer. My father was a judge of the High Court. He was a district judge directly appointed and became High Court judge. Later became chairman of many tribunals. But I have grown up in a family where I have seen that we had serious financial hardships at home, very serious. I have seen days when in the last week of every month, my father would not even have money to buy rations or petrol for the car to go to the High Court. And in those days, there was no government car, a High Court car, and he would not even call for a High Court car. He would rather walk down or go in a three-wheeler. I have seen very difficult times. I mean, throughout my college career, I had an allowance of 30 rupees per month. I was very clear that I felt that you can contribute as much as a judge as you can contribute as a lawyer. And when I think back over my 42 years of practice, I do feel that I am not disappointed myself about my contribution to the society and to the nation generally. I'm quite happy about it. But and I have been able to provide good life to my children, my wife, and myself, which is what I really wanted to. But most of it I was offered. I was offered when I was very young, a High Court judgeship by Chief Justice Venkatachalaya. And I was very young. I was 37 or 38 or 39 maybe. And they were very keen, very, very keen. But I told Chief Justice Venkatachalaya that I don't have temperament to be a judge. I have a short fuse temperament, and it's not good for a person like me to be a judge. I'm much better on this side of the bar than becoming a judge. And I have not regretted it. I honestly have not regretted.
Oh, thank you very much, sir, for this very enlightening discussion with your characteristic candor and forthrightness. I'm sure our viewers and audiences have also enjoyed it as much as I did. Thank you very much once again for sparing the time to talk to us. And thank you, everyone, for sparing your time to tune into this discussion. Thank you.
Thanks to you, Prasanna. Thanks to LiveLaw, and thanks to all the participants. Have a lovely evening. All the best.